Welcome those listeners who have come to see some sort of presentation on the amendment to the Building Industry and Fairness Security of Payment Act, which deals with project trust accounts. My name's Tony Mylne. I'm a partner at Bennett Philp Lawyers in their construction and commercial litigation section. And I'll just take you through what I intend to speak about today. I'm going to give you a bit of an overview and history of the Act and its gestation period to date, the phases of introduction that are proposed, tell you who the trusts apply to, which contracts are exempt, when is the amount liable to be paid to the subcontractor, which is a pivotal part of the Act and how it works, and deal with statutory trusts, how they're meant to work, the administration of them, the deposits, what happens on shortfall, retention trusts, training, obligations and restrictions on trustees, and QBCC powers. QBCC powers are an important change in this amended legislation as opposed to the previous legislation that was issued in 2017. And it is relied upon QBCC exercising a considerable amount of power to implement the legislation. I'll then be dealing with security under the PPSA. That is an important provision of the Act. Personal liability of executives, which is a novel set of amendments that have been introduced here, where executives will be personally liable. Amendments to Section 75, supporting statements, which will apply only in a limited way. Withholding payments, which is there to assist both subcontractors and principals, and head contractors to recover monies out of principals. Charges over property, which is principally to assist a charge by a head contractor over property that might be owned by a principal or an associated entity. Amendments to the QBCC Act and associated matters that are of some interest but are not the main thrust of this Act. Okay, I'll start firstly with the overview and history. In December 2017, the Act was initially passed. It had a very limited operation to only those contracts between $1 and $10 million, and they had to be essentially state government contracts. It was based on that experience with those provisions that the Evaluation Committee had been formed and asked to report to the government to see how these initial matters went. In March 2019, the Evaluation Committee reported to government, but we only found out about it late last year when the government actually responded to the Evaluation Committee by accepting all of their recommendations, just about all of their recommendations. And in February of this year, they issued this draft bill for comment. And eventually going through the committee stages of the bill, which has now taken place. In fact, on the 20th of February, the committee reported to government and to the minister, and while that report has been delivered to government and we have access to it, it hasn't yet been, I suppose, tabled in Parliament. And we don't know yet what the government's reaction to any recommendations of the committee are. There are essentially 12 recommendations of the committee. All of them are tinkering around the edges. Nothing of any great significance from what I can see has been recommended to change. There are some matters that I'll mention later on that will be of some concern to some parts of the industry. One has to consider, though, that in the current environment of coronavirus, etc., there might be some reticence to follow what's expected to be passing of legislation well prior to the 1st of July, which is the proposed start date of phase 2. The last week of April is the most likely date that it will be passed, but I don't even know. We don't know, I suppose, whether Parliament will be convened at that time, especially with budgets being delayed and possibly Parliament's going out of session until August, maybe as late as October. So it's up in the air, and I think probably unlikely to commence on the 1st of July if the government had any regard to the industry that might be struggling. No doubt subcontractors might say otherwise and want this legislation in as quickly as possible, but I would have thought the sensible course might have been to delay until the industry might have recovered and know whether they've got work or jobs before this legislation might be fully introduced. Anyway, we're yet to see. That's all speculation. The phases that are intended to be introduced, as you'll see from the slide, starts off in 1st July 2020, where it's state government, department and hospital and health service contracts that it will apply exceeding $10 million. You'll note that that is changed in the sense that this does not include, for instance, a state government authority. It doesn't include a local government, and it doesn't include the Commonwealth government, which are three of a very large slice of the industry who are dealing in that space. Phase 2B will be a year after that, on the 1st of July 2021, and that will be state authorities and local government and private projects exceeding $10 million. Then a year later than that, 6 months later than that, in January 2022, private projects, local government and state authorities will fill in the space in the $3 to $10 million bracket. And then from 1st July 2022, it'll be projects from $1 to $3 million that will come into the phase. Now, as I say, the commencement is difficult to say, but certainly that is roundly, I suppose, how quickly this process will take place. The theory was that it'd be the most expensive contracts would be those parties involved in those expensive contracts would be the best parties to be able to withstand, at least at an early stage, the difficulties that might arise and the problems that might arise in terms of cash flow. There's definitely cash flow consequences for all this because there's costs of implementation which are quite significant. And there are, for instance, issues to do with a lack of access to the retention fund that will have a considerable effect on some participants. And I think that's a reasonable way of going about things. Subcontractors, I think, generally would have liked to have gone a lot quicker. In a transitional sense, these will apply to unless the tender is commenced, won't apply to them if that tender had commenced before the 1st of July 2020. And then the other phases really are reliant upon the dates of the contract were entered into. So it should be relatively clear whether you fall inside or outside of those provisions and in terms of transition. Who do trusts apply to? Well, they're again not going to apply to certain things, mining work, for instance, and there are detailed provisions concerning that. There is anticipated to be a minimum contract price so it doesn't involve smaller contractors, subcontractors, and that's anticipated to be somewhere between $20,000 and $50,000. It might be lower, but we'll just have to wait and see. There hasn't been any other indication from government as yet as to what that figure will be. It will be in the regulations when they're released. The regulations have not been released as yet. The 50% of the contract price has to be project trust work, and project trust work has got a wide definition. There has been submissions made in committee that that definition should be as wide as possible. So they're in fact requesting government to make the project trust work to be quite broad, even broader than it is now, which is very broad, so that they don't miss out on anybody in the chain. Right, moving on to the super subcontractor comment I have in the slide. These provisions only apply at this stage to first tier subcontracts. So it was anticipated now for a long time that what might happen is that a contractor might in fact involve his own subsidiary or related company in the process, and they'd be effectively the first tier subcontractor, and they would deal with the subcontracting workforce as a second tier. That would simplify matters for a contractor because he wouldn't have to comply effectively. He'd be in a situation where he's leaving it to his other entity, and his other entity only deals on contracts that are secondary. So that provision has been introduced, trying to catch that sort of, I suppose, problem, and to effectively deal with people trying to avoid the consequences of the Act. There is another provision that allows for there to be certain contracts to apply under the Act. That's sort of a provision that will allow the government to regulate contracts quickly. I've never seen it really act that quickly, but it's supposed to act quickly in circumstances where there are players that are trying to avoid the circumstances or the consequences of the Act. It's not going to apply to same or adjacent sites. So, two contracts on two adjacent lots, they're going to be seen as one contract and treated accordingly. The next point I make is that principal no longer has viewing rights and step-in ability. Well, the principal, under the old Act, or the Act as it currently stands, the principal had a lot of obligations to ensure that the project bank accounts, as they then were, or as they are now, would work appropriately, and they had to report things. They really had a lot of vision, in the sense that they knew what prices or what the subcontractor was charging the contractor, and as a consequence, this was contractors didn't really want this. They didn't want head contractors to know all this information, and that was a bit of a sticking point. And now this role is now taken on by the QBCC to a great extent, although the principals do have some role. There are exempt contracts, for instance, maintenance work, where the maintenance work is the only component of the trust work. Residential construction work, where there's work less than 3 living units, they will be exempt. There may be others that are prescribed by regulation. The Act does not apply to administrative and supervisory work. Now, that's basically what they refer to as building work services. So it might be architecture and things of that nature, or administrative services, where parties are basically just doing administration, and that's all. there may be ways, and there has been some thought given to this. There may be ways of effectively where a head contractor is basically only doing administrative work and little supervisory or no supervisory work at all, or only very little. There has been questions as to whether that will be a way through not having the Act applied. But I think in the end, government will probably tighten this considerably if that's going to be used as a way of avoidance. Contract less than 90 days old, or 90 days that need a trust to practical completion, and that's fair enough, because those sorts of contracts of that sort of period are quickly resolved. They're looking at more longer term contracts. So when is the amount paid to the subcontractor? You'll see them listed on the screen there. That's a pivotal description in the sense that, or definition, in the sense that this is the timing when a payment is to be made from the bank, from the trust. And if, for instance, and you'll see later on, if, for instance, there is a shortfall, in other words, there's not enough monies in the trust to pay the subcontractors when they are due, then it is a duty of the contractor to meet that shortfall. That hasn't changed really from the previous legislation. It's worth repeating that the contractor is going to have that ultimate responsibility. And these definitions of when the subcontractor is to be paid, there's no controversy within them. They are contractually based and more likely to be acknowledged by everybody, but they are there, and that's when they are to be paid. One of the main features of this Act is that there is a significant number of penalties, in some cases jail terms, but very high penalties for consequences of offences under the Act. And one of the highest ones is the first one there under Section 18 is at 500 penalty units. Now, just so you're aware what 500 penalty units really are, they amount to $67,000 for an individual, and for a company, it's 5 times that. So you're talking about over $300,000 for a penalty. Now, these are maximum penalties, obviously, but they're still very significant penalties. They're coming down with a very hard fist upon compliance issues. That first one there is, you have to open a trust account within 20 business days after it enters the first subcontract. There has been problems in the past about banks being able to open the right sort of account. The bank wasn't really that educated about it. I would expect that the banks would be more than educated about it by now, but still, there may well be problems. 4 weeks is a long time, but at the same time, it's a very high penalty if there is a problem associated with it. You may have, for instance, a long time in the past, a long time to open up the account because you've entered into the head contract, but you may not have entered into the subcontract for quite some time after that. So in the past, there were some difficulties. They've changed that to be 20 business days after it first enters into a subcontract. So there should be no excuse now in relation to that. There are all sorts of requirements about not being a virtual account that has to have BSB, that's with a financial institution that's approved by the QBCC, that it must have an electronic record, so there is a paper trail in an electronic sense anyway, so that it can be audited and issues followed up on. You'll see the large penalties there along the way. There is possibilities of changing these accounts, transferring monies and things of that nature. And on all occasions, just about on every occasion you change anything, you've got to advise the KBCC because they're going to have a huge amount of information about every one of these contracts that this Act applies to. How they manage that might be a real challenge for the KBCC, but certainly there is a lot of penalties if you don't advise. The beneficiaries need to be advised as well in certain circumstances where there are changes, and there is only an allowance to reduce the trust account in certain circumstances. So you'll see there exemptions for payments into court to satisfy Subcontractors Charges Act claims and similar types of matters. If the contractor receives funds, which he shouldn't receive, because they should be going directly from the principal to the account, he must deposit those as quickly as possible in the trust account. And if he doesn't, there's a penalty of 2 years imprisonment, maximum penalty that is. Now, there is also a provision that no other money is to be paid into trust. That's, I presume, a money laundering issue or a possibility, and one that they want to avoid. All payments to be made through the trust, so that has to be the record. The priority in terms of funds being paid out, the contractor runs last. So really the contractor or the trustee, he must pay the subcontractor first out of those funds, then retention, and the trustee pretty well runs last. Certainly that is backed up by huge penalties again, 300 penalty units in 2 years. And if they're not paid back as soon as practical, there's another penalty on top of that. Section 51, which is the next point, is what I said before, is that if there's a deficiency, the trustee has to make up that deficiency. And if there is a shortfall and there isn't a make-up by the trustee, then the parties are to be paid proportionally, and the commissioner has to be advised, and there'll be another fine for that if there's no advice to the commissioner. Ending the trust, there are all sorts of notifications there, and you can do it obviously when there's only maintenance period left over. The retention trust, of course, would be retained, but the trust to do with payments could be wound up, and the commissioner has to be notified again. There are various provisions here that are really very mechanical about notices. You'll see what notices are required. It's by no means a complete record of all the notices that are required, but I've tried to put on a record each one that's of a more substantial nature. But there are quite short time frames. For instance, you'll see you've got to notify beneficiaries of withdrawal amounts, and that has to be notified within 5 business days. So quite, it's short time limits on occasions, and sometimes inconsistent time limits. So you can't always sort of rely upon, I've got to notify within a certain period of time. There's different time periods for each one of these notifications. It's not always that helpful. The beneficiary or the subcontractors can request information. They can request balances of accounts, copies of transaction, trust records, copies of supporting statements, which I'll talk about later, which are sworn by contractors and given to principals. And that has to be happen within 10 business days. If you've previously given some information, it hasn't changed, there's an exemption as far as that's concerned, but a beneficiary has got quite a lot of rights in terms of obtaining information that it might want, and obtain it within a very short space of time, and there's a requirement to be quite responsive as a consequence. The retention trust is the trust that thankfully you don't have to open a separate trust account for each retention and each contract. There is only need to be one trust account opened where retention funds deposited for each separate trust account or separate trust, separate subcontract. That's a significant improvement in terms of being able to administer these things, but at the same time, there will be a need to keep good records of those trust transactions. You'll see the second last point on this page, it's declared a statutory interest under the PPSA. So it's given a considerable amount of priority, in fact, the most priority that one can have as against other competing competitors for those funds. So a beneficiary ranks probably number one under the PPSA because of this legislation. So there might be claims to it by third-party mortgagees. There might be all sorts of claims to these funds, but the first dibs at it will be the subcontractor, should it in fact they be payable on the return of retention monies. There are certain further mechanical provisions about how you're supposed to name the trust, the limited nature of withdrawals, and Section 36 is quite an important provision because what it provides for, and I think there was commentary made here in the committee process, it provides for there to be only an amount of withdrawal only after the end of the defects liability period. Now, there are plenty of circumstances where monies might be drawn from retention monies ordinarily well before the defects liability period has expired. And I don't think they've really thought that through. I think that's going to provide some problems, certainly some delays in recovery of funds from the retention fund by contractors, where they would have otherwise obtained it relatively quickly and painlessly. It might again underline the fact that one of the probabilities is that there won't be retention monies per se, but there will be bank guarantees, and for those bank guarantees to be regulated by the contract and in a much more efficient manner than these arrangements. I've got to talk about training because it's one of the central, I suppose, changes in this Act is that contractors are trustees. They're going to be treated like trustees, and they're going to make sure that a nominated person is required to undertake training so that they know how to operate a trust account. They know how to document trust transactions, and they understand the obligations of a trustee and the Act. This is akin to, I suppose, in a legal office, your accounts department knowing, how the Solicitors Trust Accounts Act works. Very sort of, while they're two different Acts, there are similar obligations and similar importance are attached to them. The training issues will be significant because I would have thought that you're going to need at least, in a large organisation, you're going to need at least 2 people to cover for holidays and things of that nature. You're going to need a responsible person who'll be able to sign off on any transactions because the consequences of defalcation, dishonesty, and all those sorts of things is ever present. You need to have, I suppose, at least 2 people signing off on something to ensure that those sorts of things don't happen. That sort of training will take some lead-in time, and there will be exemptions from it. There may be organisations that already know how to run trust accounts through their experience, or have at least an idea how to run a trust account through their experience through real estate or otherwise. So there might be some people that have got some existing qualifications that might ensure that they get that exemption. We don't quite know what those exemptions are yet because the regulations haven't been issued as yet. The trustee has to pay for the training, of course, and it's another added cost to the process. I've included this next slide, just sort of supposed to reiterate some of the obligations of the trustees. So obviously you can't use those monies to pay debts or to in any way meet execution of process to meet those debts. You can't invest the monies. You can't recover fees from those monies. The only thing you can do is recover some interest once every 12 months. You certainly can't charge a fee for administering a fund. The trustee is liable for default of any of his agents, so any of your clerks who are trained basically steal funds or misplace funds or whatever, you're going to be ultimately responsible for making good those monies. It doesn't matter, there's very limited ways in which that wouldn't happen. If it's a bank's problem, I suppose one could see a bank being liable to replenish the fund, but those sorts of circumstances are probably few and far between. And normally a trustee in these sort of circumstances would have the primary responsibility to replenish the fund. So those are the sort of obligations you have. They're very serious, and if there's a breach by a third party, as I say, even one of your employees in those sort of circumstances, you're liable to make good. So serious stuff. I need to touched before upon QBCC powers, and all the way along you've seen that there's lots of notices that goes to QBCC, but they want you to do bank reconciliations within 15 business days after the month end. Complete them, you hold them, you make them available for audits. They can require information in as little as 5 days. They can freeze accounts if they suspect there are some breaches or there is some breaches in terms of the minimum financial requirements. Now, there's no real trigger point where someone's suspecting, so it's quite a wide provision, and I don't imagine it'd be subject to a lot of appeal or review, but there'd have to be some reason why they suspected it. So they have got quite wide powers here, but it certainly is a step up from where they were before these sorts of provisions. They have a lot of power. They can step in very quickly, and they don't have any real excuse if they know some information. They can step in quite quickly. as I say, they can freeze accounts, which is the ultimate, I suppose, situation. They can require reports to be obtained. They can apply for directions. They can appoint investigators, and that investigation needs to be funded by the trustee if there's evidence of the trustee contravening any part of the Act. They can discipline accountants who produce review reports that are inaccurate. There are whole provisions in the Act about how those matters can be reviewed, but they're treating this extremely seriously in terms of responsibility for trust accounts. There is review reports by auditors. Now that's likely to be on a 12-month basis, so it'll be an audit report like a solicitor's trust account. They do once every 12 months, reporting any contraventions and any problems or mistakes or anything of that nature. And if you don't engage one, well, you're going to get imprisoned or penalised quite severely. As I said before about the retention trusts, there is also a provision in here about security under the PPSA for the ordinary trust circumstance. So both of those trust accounts are in a very preferential spot in terms of other interests that there might be in those funds. In fact, the government has done all they can to make sure that a subcontractor will be in that preferred position, so long as the provisions of the Act work and there is some monies in trust when the worst happens. Now, the next section, which is a very interesting section, it's one which it will be important to a lot of people and make people hopefully sit up in their chairs and listen. There's a personal liability of executives, which is a new sort of provision within this Act. So executives are defined as people who are concerned with or takes part in the corporation's management. Now, that's a very wide definition. It's similar in some ways to the definition under the Corporations Act when they talk about phantom directors and things of that nature. So it can be quite wide. Certainly it doesn't have to be someone who's designated as a director or CEO or anything else. It can be if someone who's wielding power and making decisions that are not, being reviewed by others. They're not recommendations, they are decisions that might be applicable in this sort of context. So if they don't take all reasonable steps to ensure the corporation did not engage in conduct constituting an offence, they will be liable to a penalty, which would be the maximum for an individual, which, as we know, can be quite large. Now, it's not all of the offences that they're responsible for. It's these ones that I've now indicated on the screen. So I've narrowed it down to about 9 offences there that they're going to hold executives liable for. And when we're talking here about these sorts of provisions, you'll see they're the major provisions because they're talking about 500 penalty units, 2 years imprisonment on most of those occasions. That sort of level is very significant. As I said before, the 500 penalty units equate to about $67,000. To give you an idea, 200 penalty units equates to about $26,800, and everything in between. A penalty unit is about $134 for 1 unit, for your own edification there. Now, I should mention at this stage, I have produced, or one of my colleagues has helped me produce, a a document that sets out all the penalties in these provisions, and it sets out, I think, in a fairly readable format, those important ones that you should be compliant with and worried about. It sets out the penalty units. It sets out the penalty units for executives. It sets out the maximum penalty units. Sorry, the maximum penalty for companies. There is a provision in the Penalties and Sentences Act, which recognises, I suppose, that you can't jail a company. So when you fine, when there is talk of a fine under the Act, and it says it's 500 penalty units, it means that it's 500 penalty units for an individual. And the Act goes on to say that if it doesn't give a separate maximum for a company, the maximum for a company will be 5 times that of an individual. So for the 500 penalty units there for the first, for the failure to open a trust account, put 5 times on that, and it works out to be at $333,000. So very, very significant amounts of money, and one which would challenge a lot of companies to get over. I will, for participants or viewers of this particular webinar, I'm going to send this out to you so that you have it and have that available to scare the living daylights out of your staff to ensure that you do comply, because it's it can be incredibly hard for a business under those weights of sentences or fines. So there is a defence to these things, and that's whether you knew or should have known the corporation conducted conduct constituting the offence, and that'll just depend on the circumstances and the evidence, and whether an officer in a position to influence the corporation's conduct. So, if, for instance, you might be designated a director or some executive officer, and you don't in real life have any say whatsoever because you're 1 out of 5 and you never turn up to meetings, etc. I suppose that's going to have some effect on what you know and what your knowledge is of the day-to-day running of the business. But I think there will be a maybe room for some argument there, at least anyway. There is a new section 53BA and BB under the QBCC Act, so on a different piece of legislation, but under this same amendment bill, that interestingly, and I think quite unfairly, tries to make a new liability for an executive officer or a partner who is an unlicensed person, just to show they've got to exercise due diligence to ensure compliance by the licensee of the MFR provisions. As you know, the minimum financial requirements have been significant changes and tightening up of those provisions over the last 2 years, 18 months. There have been a significant amount of building companies that haven't been able to comply or have struggled to comply. And there have been, in the press over the last probably 12 months, examples of alleged misinformation being provided to the QBCC or incorrect reports being undertaken by accountants, whether they're misled by the executive officers themselves. I'm not quite sure, but anyway, there is a circumstance where they're trying to clamp down on these sorts of things, but you can see it really affecting mum and dad companies where the wife is at home possibly doing the books. She's unlicensed, doing her best under a difficult circumstance, but to make her also liable in these sort of circumstances, I think maybe going a little bit too far. for a third offence, there's a year's imprisonment and very significant penalties before that. What they have to do is carry out due diligence, understand the nature of the licensee's business, financial management, ensure appropriate resources are devoted to that and to ensuring that the MFR is met. And of course, the MFR has to be met not on the day that you hand in your report. It has to be met on a continuous basis. And sometimes this can have very harsh consequences. I think while they might have been thinking of larger organisations in this process, they might well catch in this net some smaller fry, so to speak, may not deserve this sort of I suppose review. Okay, amendments to Section 75. Now, this is Section 75 of the BIF Act. It requires, and it's to do with the security of payment provisions, it requires a supporting statement by a head contractor given to the principal with its payment claim. That supporting statement has to detail and swear to what subcontractors have been paid, who hasn't been paid, why not, and it's a very powerful document, I suppose, in the sense that if there's some misleading going on, there could be some consequences to it. The only consequences to it so far as that misleading is 100 penalty units, which in the grand scheme of things, I would have thought there's a lot of other penalties, other offences under this Act that might have deserved that, and that the higher penalties might be misleading parties because it goes to the heart of what the object is, that is making the money flow. And if there's someone in the middle who's lying about who's being paid and not paid, it doesn't assist the process. Anyway, that's the current circumstances. It doesn't apply to anyone further down the line. The first tier of subcontractors, it doesn't apply to, indeed, I think I'm not sure where this is really directed. There have been cases in the past where there were obviously misleading conduct about who was and who wasn't paid. This is an attempt to, I suppose, answer those sorts of criticisms by courts. Okay, this is another completely new provision, and is one of a couple that have. This is the withholding payment. Is one of a couple that is supposed to assist the principal, or sorry, the contractor to recover monies from the principal and others, and hence make the cash flow down the line. Because it's all very well saying that the money's got to flow from the contractor to the subcontractors, but it's nice to have the principals joining in if that's at all possible, because if that doesn't flow, it's very unlikely to flow to others. So in this instance, it can apply between a head contractor, principal, and even a financier. And what it requires is a series of notices where, and it only operates, I suppose, when there is a circumstance where you've got an adjudicated amount. So a fairly long way down the track, but in any case, it requires the higher party in the contractual chain to hold back monies representing that adjudicated amount, so long as it's out of the related amount payable to the respondent. So if, for instance, it's a subcontractor, head contractor, principal sort of circumstance, there'd need to be, if there's a judgment again in favour, an adjudication in favour of a subcontractor, it'd need to be the same or related amount payable by the principal to the contractor that is to be retained. So it's the same work, effectively. They've got to retain those monies and until the adjudication amount has been paid. It's a defence to say that you retain these monies for these purposes. So if for instance, the contractor sued the head contractor and saying, "You owe me this money," they said, "Well, I'm holding it for your subcontractor." So it's a defence that he can plead in any of those proceedings. The hire party can recover those monies that he holds back and pays to the subcontractor. He can recover those monies as a debt from the tier below him. So that's a significant provision. There is a provision here that says you can require identification of the hire party. That's always a problem, and there's always been a problem, for instance, under the Subcontractors Charters Act. While there's an obligation of the Act to provide these details, what happens if they don't? There is, you go to court, there's time delays, there's all these sorts of difficulties in enforcing that obligation. This is another provision, section 100 capital A to 100 capital H, which I think is novel and I think a good step. It applies to a head contractor who has a judgment after an adjudication and not been paid, and the principal has a related party that owns the property. So either the principal owns the property or a related entity of his or it owns property where the work's carried out. You can issue a charge and eventually force a sale of that property. So you can tie the money up effectively by tying up that asset. I mean, if it's mortgaged to the hilt, there's no equity in it. I suppose there might not be much joy in those sort of circumstances, but it does give the ability to put a considerable amount of pressure on the principal that is funding the project. And you would have thought a bank in those sort of circumstances would want to preserve their asset and may have some influence as well on this sort of circumstance. But it does give you that extra arrow in your quiver. And a related entity is quite an extensive definition. I won't go into it because it's quite complex, but it is quite extensive. And those are the provisions in short there under section 10A. The court can make an order for sale, as I say. It's a powerful provision. Amendments to the Security Payment Provisions, QBCC Act. This is section 42, capital E. These amendments have been made to allegedly make it easier for the QBCC to prosecute parties who are not complying by deliberately avoiding or the provisions of the Act, or deliberately non-complying with contracts, should I say. It may well. I'm not altogether convinced that this will actually result in more prosecutions, because there has been none to date. While they might argue that it will be easy to prosecute, the methodology they use is that the it's the onus of proof to provide a reasonable excuse will be on the defendant on the balance of probabilities. Yeah, I don't know whether it's going to make it any easier to prosecute. It might, but it'll be good to see them actually attempt to prosecute someone, because they haven't even attempted to do that at present. The prosecution time has increased from 2 years to 3, which is, I suppose, significant in the scheme of things. These amendments to the supervisor's license, I think, are interesting to the extent that if you're now a excluded individual under the QBCC Act, you won't be able to in the future hold a site supervisor's license. So, you know, the employment of excluded individuals is lessened because of this. I'm not sure why they think this is a great idea, because there are lots of people who, no doubt, are good builders and possibly very good supervisors, but not very good businessmen who will be lost to the industry, at least in this way. But in any case, that's going to come in on proclamation. But when you're actually engaging prospective site supervisors, it should be part of your process to make sure that he isn't an excluded individual. Do your searches with the QBCC, find out exactly what his history is, because there is absolutely astronomical penalties if you're not having a site supervised by an individual who's licensed. 1,000 penalty units, so 1,000 penalty units, that's 5,000 penalty units for a company. I almost can't compute that, but anyway, it's a lot of money. It's certainly over, yeah, so it's a lot of money. Now, the other amendments have the object of also ensuring that our friends from across the ditch in New Zealand don't also are not suspended or cancelled licenses over there. So they're anxious to avoid those parties becoming a site supervisor, a licensee, a nominee, and they are going to be harder to determine. I haven't yet checked what public resources are available in New Zealand like they are here, but it's one thing that one should be mindful of. We need to do that, and that be part of your process as well. Thanks for your attendance. I just mentioned 2 last things. During the course of the recommendations that have been made by the committee who was reviewing this bill and making 12 recommendations, one of them was recommendation 9 that Schedule 1A of the QBCC Act be changed. There was an exemption under Section 1A for unlicensed contractors in circumstances where that contractor engaged a licensed contractor to do the licensed works. In my experience, that's happened on a few occasions to assist within a group, but it's also happened on occasions where there are interstate or overseas companies that come in not licensed but engage effectively another licensee to engage subcontractors. Bit the same as the super subcontractor, or the super subcontractor as I referred to earlier. I'm not sure why they don't think these provisions are working well, but that's what the recommendation was. Whether it has any traction at all with the minister, I'm not quite sure. I suspect it might have something to do with competition, but that's yet to be seen. The other issue is there's been no recommendations at all concerning the endorsement on a payment claim. You'll remember, or hopefully you remember, that currently there is no requirement for an endorsement on a payment claim, and that a lot of things could be a payment claim. If you request money, it's a payment claim. And that has a lot of consequences that have been rammed home to the minister and various other parties interested in drawing this legislation. And those consequences being that, people are sending payment claims when they don't really want to, and using up reference dates when they shouldn't, and that might come back to bite them. Equally, a respondent doesn't recognise that they're payment claims, and as a consequence, puts themselves in a very difficult position where they haven't issued a payment schedule within the required time. I don't see the necessity to it, and it is a situation which has been changed in New South Wales for these very reasons. Okay, thanks for your attention. I hope you all got something out of it, and we'll see you next time. Bye.